with regard to the case that's on the docket.
Sorry. With regards to that case, Your Honor, people are unable to proceed.
All right.
Move to dismiss, Your Honor.
People being unable to proceed, that case, that being 1487, that case is dismissed. That is without prejudice.
I don't think Ms. Hines stated her name. Can you state your name, Ms.
Maya
Hines?
High.
All right. I do have another case for Ms. Hines. I don't know. You know, in which she has a warrant. It's a case of retail fraud. You were set to appear before the magistrate, did not. A warrant was issued on that case. What I will do is this, that I'll arraign you on the warrant in the case. Ma'am, that case alleges that on or about January 7th, 2023, at the location of the Meyer store, 3825, or the other one. At the location of 3825 Carpenter Road in Pittsfield Township, Washington County, State of Michigan, that you did commit the offense of retail fraud in the third degree. Do you understand the nature of that charge, ma'am?
Yes.
All right, that is a misdemeanor, punishable by up to 93 days in jail, $500 fine plus court costs. Fine could be increased if 3 times the value of the property taken. If that's greater than $500, that would become the maximum fine. Do you understand that?
Yes.
All right. First question I have for you, you want to be represented by an attorney?
Yes.
This is a public defender case.
Assistant Public Defender Lauren Kearney on behalf of Ms. Hines will waive formal reading and stand mute to the charges.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea to that charge. I will set a pretrial in this matter for.
The judge cancels the bench warrant but replaces it with a bond conditions. That's the court basically saying, I'll let you walk today, but I'm putting you on a leash. And the no Meyer store in Michigan condition, that's a classic no contact, no return order to prevent repeat incidents.
November 5th, 2025, 9 a.m. or as your invite indicates. With reference to bond in this case, I will cancel the bench warrant in this matter. I will then set a bond in this case, amount of $5,000. Personal recognizance of other standard conditions, including no assaultive behavior or possession of any weapons. You understand that, ma'am?
Yes.
I'll also indicate you're not to possess or consume any alcohol, recreational marijuana, or any illegal drugs at this time. You understand that? I will also indicate that at this time also you are not to enter any Meyer store in the state of Michigan. You understand that?
Yes.
All right. Thank you. See you on the 5th. Let's call the case People versus Jalen Robinson.
Good morning, Assistant Public Defender Lauren Kearney on behalf of Mr. Robinson, who is approaching. State your name, sir.
Jalen Robinson. All right. I have before me a plea form. Is that what we're doing?
Yes, Your Honor.
My understanding is the defendant is going to be pleading guilty to the as charged to domestic violence, the 93-day offense. Upon a successful plea to that charge, at sentencing, the defendant, there is an agreement that he will be sentenced under 7694A.
A deferred program is basically the court saying, earn your dismissal. But it's not free. It's a strict test. One mistake and that leniency can vanish. This is why plea hearings are intense. You're giving up trial rights for a chance at avoiding a conviction. Would you take that deal or fight it?
The deferred program. That's the court's full understanding of the agreement.
Correct, Your Honor.
Correct.
Oh, very good. May I have him sworn?
You solemnly swear or affirm the testimony you're about to give be the truth, whole truth, and nothing but the truth have you got. Lower your hand and state your name.
Jalen Robinson.
All right, sir, it is this court's understanding you're going to plead guilty to the charge of domestic violence. That is a misdemeanor, punishable by up to 93 days in jail, $500 fine plus court cost. You understand that?
Yes.
All right. And understanding that, do you still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
Guilty. Guilty.
Thank you. Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes,
You signed an advice of rights form today, is that correct?
correct.
Any question regarding any of those rights?
No.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes,
You understand you're giving up your right to appeal of right.
yes.
Are you on probation or parole?
Nope.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No.
Anybody threaten you or coerce you?
Nope.
You're doing this voluntarily
Yes,
of your own free will
yes,
and because you believe that you are indeed guilty of this offense?
yes,
On the date of July 11th, 2022, at the location of 4820 Washtenaw, apartment B11, Pittsfield Township, Washtenaw County, state of Michigan, what did you do on that date involving a Giovanna DeMarco that makes you think that you're guilty?
just touched her when she didn't want to.
Okay. Were you guys involved in a fight of some type or an argument?
Argument,
You were involved in an
Verbal.
argument
verbal argument.
and you touched her in some fashion?
Yes, and without her consent.
Pardon?
Yes, without her consent.
Can we briefly vote for a minute?
Me? So you said you touched her and she didn't, where did you touch her?
More so like the waist.
All right. And you didn't have her permission to do that?
No,
Okay. And you did that intentionally?
no,
You didn't touch her intentionally.
Hmm?
He's asking if you touched her intentionally, like it wasn't an accident, like you touched her,
like it wasn't an accident,
that you touched her,
like on purpose.
yes,
So yeah.
yes.
Okay, yes.
The court needs a clean record that the act was intentional and without consent. If the defendant keeps sounding unsure, the plea can collapse because there's no solid factual basis. This back and forth is the judge building a case, proof, transcript, so the plea doesn't get overturned later.
Okay. I'll ask the question again. Did you intentionally touch her when you said you touched her on the waist?
Okay, yes.
You did? Okay. And that was without her consent, as we've established.
Correct.
Correct. And what is her relationship to you?
Right now, or nothing.
It's probably not good right now, but what was it at the time?
I'll say dating. Dating. Yeah.
I'll say dating.
Yeah. Because we wasn't
What was your relationship with her?
we wasn't boyfriend, girlfriend, so I'll say dating. We were intimate. I don't know.
Okay,
Dating.
that works. Just stop it. All right. Sir, if I accept your plea, I do have to advise you that if you commit misconduct between the time of my acceptance of your plea and your time of sentencing, that the court would no longer be bound by any sentence agreement or evaluation of your case. You understand that?
Yes.
And also you would not be permitted to withdraw your plea. You understand that?
Yes.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No,
No, Your Honor.
All right, and have the court complied with the court ruling, would it be proper to accept this defendant's plea?
yes, Your Honor.
Yes, Judge.
Court will accept the defendant's plea of guilty to this charge. Defendant is referred to probation for a pre-sentence investigation and report. Sentencing in this matter will be November 12th, 2025, 9 a.m. Bond in this matter with its conditions will be taken. Thank you, sir. You can stop by probation on your way out the hallway. They'll be on your left.
Okay.
All right, thank you. Court does call the case People versus Samira, is it Takora?
Alexander on behalf of the people.
Assistant Public Defender Natalie Pay on behalf of Ms. Takora, who I do not know or if she's present, Your Honor. I have had, oh, perfect, she's here. We talked on the phone. Mr. Cora, I apologize. Please state your name for the record.
Samira Thaikora.
Thank you.
Your Honor, at this time, people are unable to.
Motion to dismiss, Your Honor.
People being unable to proceed, this case is dismissed. That's without prejudice. Thank you, ma'am.
Thank you, Your Honor.
Court does call the case of the people versus Nicholas Stimmel.
That's false for people.
And good morning, Your Honor, for the record.
Yep.
Good morning, Your Honor. For the record, Rita Young, appearing on behalf of Mr. Nicholas Stemmel, who is present standing to my right. Sir, would you state your name for the judge?
Nicholas Stimmel.
Thank you. I thought since you hadn't been here in so long, Michelle, you just forgot where to stand.
Kinda.
It is good seeing you.
Likewise, Your Honor.
All right. I have before me a plea form that indicates that the defendant will be pleading no contest to the charge of assault and/or assault and battery, the 93-day offense. On his successful plea to, that's pleading as charged, there is an agreement as to sentencing that a prosecutor's deferred sentence with probation would be the sentencing case.
That is completely correct presentation of our agreement.
And Your Honor, it's my understanding that if successfully complete probation, the case will be dismissed.
That's right.
As part of the prosecutor's deferred. That's correct. All right. May I have him sworn?
You solemnly swear or affirm the testimony you're about to give, the whole truth, and nothing but the truth, so help you God.
Yes, I do.
Lower your hand and state your name.
Nicholas Stimmel.
Sir, it is this court's understanding that you're going to plead no contest to the charge of assault and/or assault and battery. That's a misdemeanor punishable by up to 93 days of jail, $500 fine plus court costs. Do you understand that?
Yes, Your Honor.
All right. Do you understand what a no contest plea is?
Yes, Your Honor.
All right. Two things about it. I have to make sure that you understand it. First of all, means that you're not further desirous or wanting to contest this charge. You understand that?
Yes, Your Honor.
The second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes, Your Honor.
All right. Still, basis for the no contest plea.
Civil liability,
All
possible.
right. Still wish to plead no contest?
Yes, Your Honor.
And to that charge, how do you plead?
No contest.
Now, you understand that by pleading no contest, you'll not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form, is that correct?
Yes, Your Honor.
Any questions regarding any of those rights?
No, Your Honor.
Please look at paragraph 5 on that form. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading guilty or pleading no contest, you're giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
of your own free will.
Yes, Your Honor.
And well, I won't ask the last question. The court has been provided Pittsfield Township Department of Public Safety report for their case number 24-16014. Any objection to the court having reviewed that report?
None from the people.
None from the defense, Your Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Sir, after I accept your plea in between the time of your plea and the time of sentencing, if you commit misconduct as defined by the Michigan court rules, you would, any sentence evaluation or recommendation to the court would no longer be bound by. You understand that?
I understand that, Your Honor.
And you also understand that you would not at that time also be allowed to withdraw your plea. You understand that?
Yes, Your Honor.
Is counsel aware of any other promises, threats, or other inducements which have led to this plea?
None, Your Honor.
None, Your Honor, and it sounds like the court's not amenable to immediate sentencing.
I wasn't asked, but
Oh, okay.
by being asked, no. All right.
Yes, sir.
You just don't want to come back here, do you? You're just trying to make it like a one-stop. I couldn't do that in any event because of the nature of the charge, and it's a victim's rights case, so I'd have to have him evaluated on that. But have I complied with the court rule?
You have, Your Honor, as usual.
Yeah, right. Court will accept the defendant's plea of no contest to this charge. Defendant is referred to probation
Thank you, Your Honor.
for a pre-sentence investigation and report. Sentencing in this matter will be November 12th, 2025, 9 a.m. or
Judge.
slide indicates. That's why we don't let her come. Go ahead. What?
I'm so sorry. I have a jury trial scheduled to start in Wayne County on November 10th. And it's a CSC case, so it's going to run through the 12th, I'm sure. So I'd ask for a different sentencing date, please.
You know, I almost want to say no.
Can I zoom in for sentencing then?
No.
Okay.
No. We're gonna make you come here.
Very well.
Can we? The 10th?
Yes.
10th is when the jury trial starts.
Can't
Oh,
do-
December
can't-
10th, you said? Oh, that's great. Perfect.
Sure.
Yes, Your Honor. Perfect.
Sentencing will be December, actually, the 12th was perfect too, but you just messed that up. December 10th, 2025, 9 a.m. or as your invite indicates, bond with its conditions will continue. Thank you, sir.
Thank you
Your
so
Honor.
very much, Your Honor. Good to see you.
Take care. Court calls the case of the people versus James Baltes.
Ellen Zen on behalf of the people.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Baltas. State your name for the record, sir.
James Lee Baldus.
Thank you.
At this time, you are unable to proceed.
Move to dismiss.
People being unable to proceed, this case is dismissed. That is without prejudice.
Thank you, Your Honor.
All right, thank you, sir.
Thank you.
Court does call the case, people versus Jason Eckel.
The people.
Good morning, Your Honor. Robert Goldman, PA 1222, appearing on behalf of alongside defendant Jason Michael Eckel, present in the courtroom this morning. Mr. Eckel, would you please state your full name for the record?
Jason Michael Eckel.
All right. The plea form that the court has in front of it is that the defendant is going to plead to an added count 2 of operating while visibly impaired to second offense. The 1-year offense. Upon the successful plea to that charge, count 1 would be dismissed. Defendant is also agreeing to enter and participate in sobriety court. Is there a particular sobriety court that he's going to be entering, or?
I'm not sure that he's been screened yet, Your Honor. Counsel and I had the chance to discuss this morning, and he let me know his client's interest in sobriety court. And given some of the facts and background here, I think that's a really good option.
Got
So
it.
I don't know that he's been screened.
Screened as, okay, but he does agree to do that. Is that correct, counsel?
Yes, Your Honor. And he is a resident of Ypsilanti. And so
You're not, right?
I'm not, no, Your Honor.
I could tell by the way you said Ypsilanti, but go ahead.
Sorry. So we are open to a sobriety court that has room for admission. I do believe that he would qualify as a resident of Washtenaw County. And otherwise, we anticipate it to be a successful screening for admission.
Okay, and I mean 14A has a,
I
Yeah.
think that would be a good place to start is 14A.
Yeah.
okay. And that's the court's full understanding of the agreement. Is that correct?
Yes, Your Honor.
Accurate, Your Honor.
All right, may I have him sworn?
Raise your hands. Do you solemnly swear or affirm the testimony you're about to give be the truth, whole truth, and nothing but the truth, so help you God?
Yes.
Lower your hand and say your name.
Jason Eckel.
Say that again. You.
Jason Eckel.
All right. Sir, it is this court's understanding that you're going to plead guilty to the charge of operating while visibly impaired second offense. That is a misdemeanor punishable by up to 5 days to 1 year in jail, up to $1,000 fine plus court costs. The court could order community service or any rehabilitative services the court deems necessary. The court could order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand all of that, sir?
Yes, Your Honor.
And understanding that, you still wish to plead guilty.
Yes, Your Honor.
And to that charge, how do you?
Guilty.
You understand that by pleading guilty, you'll not have a trial of any kind.
Correct.
You signed an advice of rights form, is that correct?
Yes.
Any questions regarding any of those rights?
No.
Please look at paragraph 5. Those are your rights, which are part of a trial. You understand by pleading guilty of those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
Besides my wife, no.
All right. You You're doing this voluntarily,
Yes,
of your own free will,
yes,
and because you believe that you are indeed guilty.
yes.
All right. On September 4th, 2024, at the location of 3900 Carpenter Road, Pittsfield Township, Washtenaw County, State of Michigan, were you operating a motor vehicle?
Yes, remember the questions we went through?
Yes, yes,
Prior to operating that motor vehicle, did you consume intoxicating liquor?
yes.
What you have and how much?
Mike's Hard Lemonade, about 3/4 of a tall boy.
Okay. Were you stopped by the police or was there an accident?
Your Honor, there was a welfare check was conducted. Officers responded by way of a dispatch for welfare. Mr. Eckel came into contact with officers in the parking lot of a Lowe's retailer in light of the welfare check response.
Got it. Okay.
No accident involved, Your Honor.
Okay. And ultimately, were you arrested
Yes,
and were you taken to the hospital for a blood draw?
It's an intoxilizer case, Your Honor.
All right. And were the results of that intoxilizer 0.09 and 0.10?
yes.
Do you have any reason to dispute those results? All right. Taking everything into consideration on that date and at that time, do you believe that your ability to operate that motor vehicle was visibly impaired due to your consumption of alcohol?
Yes,
All right. And had you previously been convicted of operating while intoxicated on or about December 6, 2021 in the 1483 District Court?
yes,
All right. Sir, if I accept your plea, between the time of my acceptance of your plea and the time of your sentencing, if you commit misconduct as defined by the Michigan court rules, you would not be entitled to any sentence evaluation or recommendation. The court would no longer be bound by that. You understand that?
yes, Your Honor.
You also understand that you would not be entitled to withdraw your plea.
Yes, Your Honor.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
None, Your Honor.
All right. And has the court complied with the court rule? And would it be proper to accept this defendant's plea?
The people are satisfied.
So satisfied, Your Honor.
All right. Court will accept the defendant's plea to count 2. Count 1 is dismissed. Defendant is referred to Von Swartz for an alcohol screening and assessment and the victim's impact panel. Sentencing in this matter will be here on November. I'll set it for November 12th, 2025, 9 a.m. Bond will continue with its conditions. What I'm going to suggest to you, counsel, is to go down to probation at this point in time, indicate his interest in sobriety court, and see there are 2 probation officers working down there at this point, my probation, as well as the sobriety court probation person. So let them know that and let them direct you as to how he should proceed.
Will do, Your Honor. Thank you.
Thank you. Court calls the case, People versus Eric Buckner.
Alexander, we have 2 people.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Buckner, excuse me, who stands to my right. Please state your name for the record, sir.
Eric Buckner, how you doing today, sir?
Thank you. I have a plea form indicates the defendant is going to plead to domestic violence second offense, the 1-year offense as charged. And that upon his plea, the prosecutor will recommend defendant's pending domestic violence case in the 1482 District Court will be dismissed with a nod.
That is the complete understanding of that agreement, Your Honor. Yes.
All right, very good. May I have him sworn?
You solemnly swear or affirm the testimony you're about to give be the truth, whole truth, and nothing but the truth. So help you God.
Yes.
Lower your hand, state your name.
Eric Buckner.
Sir, it is this court's understanding. Excuse me one moment. This is court's understanding that you're going to plead guilty to the charge of domestic violence second offense. That is a misdemeanor punishable by up to 1 year incarceration or $1,000 fine plus court cost. Do you understand that?
Yes, Your Honor.
And understanding that you still wish to plead guilty?
Yes,
And to that charge, how do you plead?
guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights?
No, sir.
Look at paragraph 5. It's on the podium. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily
Yes.
of your own free will
Yes, sir.
and because you believe that you are indeed guilty of this offense?
Yes, sir.
On the date of May 2nd, 2025, at the location of 3000 Carpenter Road, Pittsfield Township, Washington County, State of Michigan, what did you do to Tamika King that makes you think that you're guilty?
We ended up getting into a physical altercation. So,
Okay, so you were in an argument,
Yeah.
and what did you do with reference to that physical altercation?
it got physical.
Pardon?
Me and her, it got physical.
Okay. What did you do?
Oh, I put my hands on her. That's basically what you're saying, sir.
Okay. And you didn't have her permission to do that?
No, sir.
All right. And you weren't acting in self-defense at the time?
No.
All right. And you did that intentionally, is that correct?
Yes.
All right. And who is she to you?
My ex is my ex-wife.
At the time, was it your ex-wife?
No.
Okay, at the time it was your spouse.
Yes.
All right. Had you previously been convicted of the same type of an offense on or about, I don't have it here.
Your Honor, I have the date on the offense numbers of 6/18/2013. The previous.
6/18/2013.
Correct.
All right. Had you previously been convicted of domestic violence on that date?
Yes.
All right. Sir, if I accept your plea, between the time of my acceptance of your plea and the time of your sentencing, if you commit misconduct as defined by the Michigan court rules, you would not be entitled to any sentence recommendation or evaluation. The court would not be bound by that. You understand that?
Yes, Your Honor.
And you understand that you could not withdraw your plea.
Yes.
All right. Counsel, are you aware of any other promises, threats, or other inducements which had led to this plea?
No, Your Honor.
No, Your Honor.
And has the court complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea to this charge. Defendant is referred to probation for a pre-sentence investigation and report. Sentencing in this matter will be
November 10th. Oh, no, November 17th, sorry.
November 17th, 2025, 1 p.m. I don't, what I was going to indicate, I don't know if on that other DV case, I think we got the wrong day.
We corrected it.
You corrected it.
Yes.
Okay, very good. All right. Bond will continue with its conditions. Thank you, sir.
Thank you, Your Honor.
Court calls case of the people versus the Darians. Is it Staffney Town
Ashley Feltes for the people.
or Staffney Town?
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Staffney Towns. State your name for the record.
Adarian Townsend. I really don't go by Staffney. I got two last names, but I really only go by Townsend.
But you got two names.
I know. I don't know why my mom did that.
You don't know what?
Why my mom did that.
But you don't like it, so you just keep one?
Yeah. I'm sorry. I just keep one. Yeah.
Is it the first one or the last one?
The last one, Townsend. Adarian Townsend is what I go by. With Staffney Townsend.
What's your mom say about that?
Like, my mom's last name is Townsend. My dad's last name is Staffney. So she just gave me both.
Oh, what's your dad say, but you don't want to carry his name?
No.
Oh, well, never mind. My bad for asking. All right. Okay. I get it. All right. What are we doing on his case?
Unable to proceed, Your Honor.
All right.
Move to dismiss.
People being unable to proceed, this case is dismissed.
All right, thank you.
Good to go.
That's without prejudice. You take care of whatever your name is. All right. Court does call the case, People versus Roman Hop.
Ashley Phelps for the people.
Good morning, Assistant Public Defender Lauren Kearney on behalf of Mr. Hop. State your name for the record, please.
Ramon Hop.
All right. I have before me a plea form that indicates defendant will be pleading guilty to the charge of malicious destruction of property. 200 to 1,000, which is the 1-year offense, which I think is the stated count. Upon a successful plea to that charge at sentencing, the prosecutor will recommend a probationary sentence, and the victims are waiving any right to restitution in this matter.
That is correct, Your Honor.
All right.
That's our full understanding.
All right. Very good. May I have him sworn?
Raise your right hand. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so you got?
Yes,
Lower your hand, state your name.
Ramon Hop.
All right. Sir, it is this court's understanding you're going to plead guilty to the charge of malicious destruction of property, 200 to 1,000. That is a misdemeanor punishable by up to 1 year incarceration and $2,000 fine plus court costs. The fine could be increased if 3 times the value of the property destroyed or otherwise injured. If that's greater than $2,000, that would become the maximum fine. You understand that?
Yes.
All right. Still wish to plead guilty
Yes,
to that charge? How do you plead?
guilty.
You understand that by pleading guilty, you will not have a trial of any kind.
Yes,
All right. You signed an advice of rights form. Is that correct?
yes,
Any questions regarding any of those rights?
no,
No? All right. On the podium, you'll see a copy of one. Please look at paragraph 5, the highlighted one. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
yes,
You understand you're giving up your right to appeal of right.
yes,
Are you on probation or parole?
no, sir,
Has anybody promised you anything other than what's been stated here today to get you to plea?
no,
Has anybody threatened you or coerced you in any way?
no, sir,
You're doing this voluntarily
correct.
and of your own free will,
Yes, sir.
and because you believe that you are indeed guilty of this offense?
Yes, sir.
I'm sorry.
Yes, sir.
Yeah, okay, thank you. On the date of December 26, 2024, at the location of 2564 Deke Avenue, Pittsfield Township, Washtenaw County, State of Michigan, what'd you do that makes you think that you're guilty?
I destroyed a statue and a doorbell camera.
Okay. And so this was at a residence that you did?
Yes, I used to live there.
Pardon?
I used to live there, sir.
You used to live there. Okay, but you don't?
No.
You didn't at the time?
Not for years.
Okay. And so you destroyed those things. You didn't have any property interest or ownership in any of those properties.
I had some property at the house stored, but I was there also that day to get that property back.
Okay, I got you. But as to the statute and the Ring camera, those weren't.
No, correct.
You didn't
correct,
buy either
No.
one of those, correct?
Correct.
Okay. And you didn't have the owner's permission to destroy any of that property or do anything to it. All right. And you did that intentionally, sir?
Yes.
All right. Would you stipulate or agree that the value of those two items combined was in excess of $200?
Yes. Like
That's-
excess or it was,
Yeah, it was more than $200.
$200 or more.
yes. Yeah.
You would agree to that?
Yeah.
Okay. Sir, if I accept your plea, in this case, I have to advise you that between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined by the Michigan court rules, the court would no longer be bound by any sentence agreement or evaluation in the case. You understand that?
Sir.
And you would not be entitled to withdraw your plea. You understand
Yes,
that?
sir.
All right. Counsel, are you aware of any other promises, threats, or inducements that have led to this plea?
No, Your Honor.
All right. And have I complied with the court rule? Would it be proper to accept this defendant's plea?
Before satisfied.
Satisfied, Judge.
All right. Court will accept the defendant's plea to this charge. We'll count one. Let's stay. Defendant is referred to probation for pre-sentence investigation and report. Sentencing in this matter will be
November 12th at 9 a.m.
November 12th, 2025, 9 a.m.
Your Honor, I know your next sentencing date is the 22nd. I know that's a quick turnaround, but given Mr. Hop's time he's done, we are asking for the 22nd.
His time is done.
Defense is saying housing is slipping away, and the judge is saying structure and safety first. The judge isn't just worried about this case, they're worried about violations, instability, and risk to the public and victims. That line about needing an absolute plan is the court demanding accountability. Who supervises him? What program? What rules? What consequences? Real question, should housing access ever outweigh public safety concerns, or is the judge right to hold the line?
He's been in custody for quite some time. He's eager to get assessed, get seen by probation,
For housing.
get this case resolved.
Go ahead.
We were also going to renew our bond request that the motion was on Wednesday, and this court denied that motion. He did want to renew that request. That housing is still, present for him. We just don't know how long it's going to be available. So that's why we're requesting such an urgent date.
I do think he's still held on the felony, just so the court knows, Your Honor.
Yes, that bond's $100.
Yeah.
Is he going to be able to post that? Or-
He thinks he may be able to. I mean, this is bond denied, so obviously this is driving the bond truck here.
Sentencing will be before the 27th.
The 27th, so the original.
Right, because he had violated the terms of his release, it's just why his bond was denied.
Right.
Um,
The date I asked for.
I just don't think, and I can't. You're basically asking 3 days from now for probation to be able to interview him and do everything, as well as talk to the victims of this, and I just don't know that that's going to happen. I mean, if I set it for that day, I don't know that we're going to have all of the information that we need. So I'm going to set it for the 12th. That
If I'm sorry. I can talk to probation maybe if things are done quickly. We'll contact the court if depending on what Ms. Pilara can.
I just don't want to lose my housing.
Yeah, we're just really concerned about the housing issue, Judge.
No, I understand that, but I
It's
also
6 years.
have to try to put things on a reasonable time frame and don't want to stress my probation department either. But
I will add, if I may, regarding the bond argument. I know the court said you would consider any additional information that I was able to obtain. I did reach out to CMH to see what they recommended as for a mental health plan moving forward. The gentleman, Mr. Hop's caseworker, and just indicated that housing was their primary focus, that the CMH's mental health recommendation moving forward was to get him into housing. So they didn't have anything additional to add that he's already doing, which is he does report to CMH for medication. So I don't have anything else. I know the court requested that information. I don't have anything else to add, except for that was their, primary recommendation for his, mental health journey. So again, that's why we're just trying to make things happen,
Yeah.
Judge. Obviously, the county has to do what they have to do with the housing, but we want him to be able to take advantage of it if possible.
anything else from the people?
No, Your Honor, I think I've made my position pretty clear to the court with our bond motion on Wednesday, and the court understands the struggles with secured housing,
Yes.
but also understands the struggles with bond violations that lead to new cases and all the things that are sort of going on in the periphery of that issue.
I don't see a basis on which I would change my decision. I think I would still keep his bond as denied. I'd like to see everything regarding his sentence and know as much as I possibly can about this. The events, as I understand them, are a bit concerning to me, and then the violation on top of that adds concern. While I'm certain he would be going into Avalon Housing, you talked to CMH. first thing is I'm not gonna do anything until I see an absolute plan as to what some structure around him that's gonna prevent further activities by him. So that's gonna be one thing, but I also want to see the full outlay of it. And particularly, I want to make sure that the victims of this offense, that their views and what they might say to probation are fully considered by the court before releasing it. So I'm going to deny again the request for a bond reduction. All right.
I'll see what I can.
All right. Thank you.
Thank you.